I will call the next case. This is Andrew Campbell versus the Michigan Department of Treasury. It's a 15-minute oral argument, mini oral argument. And I'm sorry, it's not a mini oral argument, it's a full case call. Mr. Ziehmer, you can proceed and try to reserve some of your time. I'm sorry, you have 20 minutes. I'm messing up a lot today for rebuttal. And Mr. Long, we appreciate your being here to argue on behalf of the real property law section of the State Bar. We're grateful for your participation. It will help us in thinking through these issues. And you may proceed, Mr. Ziehmer.
Good morning. May it please the court, James Allen Ziehmer appearing today on behalf of the Michigan Department of Treasury. If possible, I would like to reserve 3 minutes of my time for rebuttal. I will attempt to manage my time. Like a discount or a coupon, a principal resident exemption, a PRE, applies to reduce the amount of tax that is being assessed against real property. When it's denied, the assessor is removing the exemption of the property. The tax roll is being amended to reflect the denial. And the local treasurer or the county is issuing a corrected tax bill. And that's an important component because they're billing for that additional amount of taxes that would otherwise lawfully be due and owing. By interpreting subsection 4 of MCL 211.7 CC as applying to denials, not only is the taxpayer getting the benefit of not being billed or having to pay those taxes that are otherwise lawfully due and owing, it's giving the taxpayer the ability to nullify the denial because all they have to do is file a new PRE affidavit the subsequent tax year, and it starts the process all over again. Subsection 4 of the statute is not the only subsection that addresses what the assessor is supposed to do. Subsections 5, 6, 8, 11, and 15 all independently address and provide direction to the assessor as to what they were supposed to do. Subsection 8, which is applicable to this case, not only provides the authority to Treasury to issue the denial, but if you're reading electronically about 12 to 13 lines down, it provides the direction to the assessor. Upon receiving notice of the denial from Treasury, the assessor shall remove the exemption of the property. If they're in possession of the tax roll, they are to amend the tax roll to reflect the denial. And then within 30 calendar days of the date of the denial, the local treasurer, or if it's the county, is to issue a corrected tax bill for that additional amount. This makes sense when read with subsection 4's condition preceded in its introduction, unless the claim is denied under the section. Subsection 4 is establishing just a general framework that, unlike other types of tax exemptions, the PRE only needs to be filed once and it will stay on the books. And reading the statute in its entirety, it's operating almost as a carrot and stick approach, if you will. It's incentivizing individuals to file voluntary rescissions, which they're required to do so under subsection 5, but it's also providing the stick, which is Treasury, the assessor, as well as the county, if they have to catch the person, can remove the exemption from the property retroactively and then bill. And there's penalties as well as interest. Interest cannot be accruing unless that additional amount is being billed to the taxpayer. So reading the statute in its entirety, it's fairly clear and it's consistent with common sense that when the denial has occurred, and there's other language in the statute, such as subsection 3, that the taxpayer is not entitled to the exemption in any calendar year. What we're talking about is the removal of the exemption for that calendar year. And to be even more clear, this wasn't necessarily clear in our briefing, but we're always talking about December 31st, which is tax day. The question is, which December 31st are we talking about? The December 31st for the calendar year at issue, or the December 31st for the following calendar year?
Mr. Ziehmer, let me interrupt you and see what questions folks have. And if you have more time, we'll come back to your presentation, okay? I'll start with Justice Bernstein.
Hi, Counsel. Good morning. And again, I always like to keep it simple. What difference does it make that this person is a lifelong Michigan resident?
It doesn't make any difference, Your Honor. way subsection 3 operates, it is if any of the conditions in subsection 3 occur, it's an automatic denial. It's an automatic loss of entitlement to the exemption. So for purposes of the way the statute operates, if they were to file a voluntary rescission, the PRE would still stay on the books for that year unless it ends up getting denied. And the denial, again, is retroactive. So factually, the fact this individual is a lifelong Michigan resident is largely irrelevant to how subsection 3 operates.
Thank you, counsel.
Justice Clement.
Good morning, Mr. Ziehmer. So following your argument, I guess I'm wondering what your position is on what the function is for the clause at the end of subsection 4 that references scenarios when the owner is no longer entitled to an exemption as provided in subsection 3. My understanding of you reading the statute, couldn't we just delete that clause and have subsection 4 mean the same thing, or am I missing something?
No, Your Honor. So largely our argument in the briefing was addressing the conflict that's going to be created within the statute if we are to read subsection 4 as applying to denials, because then there's going to be ambiguity and conflict and tension between the various subsections. But to understand the clause, it's really talking about 3 different scenarios. And so we have transfer of ownership, we have whether the property meets the definition under 7DD of a principal residence, and then subsection 3 is really about use. How the person's using the property. And so going to subsection 3, in all those different scenarios, whether we're talking about an individual that's filing tax returns as a non-resident, or they're receiving a principal residence in another state, those are all situations where they should be filing a rescission form pursuant to subsection 5. So the statute, subsection 4 still makes sense, reading as just applying to rescissions. There's no need to read it to have to apply to denials.
Okay, thank you.
Justice Cavanagh.
No questions.
Justice Welch.
No questions.
Justice Zahra.
Thank you. As I understand it, you're claiming that MCL 211.7 CC subsection 4 contains the clause, quote, unless the claim is denied under this section, end quote. And as taking that phrase, I understand your argument to mean that this clause means that subsection 4 does not apply when a personal residential exemption claim is denied, whether it's new or existing. Is that accurate?
That is accurate, Your Honor.
Okay. So then would that not render the rest of subsection 4 nugatory, as pointed out by the amicus?
No, it absolutely doesn't, for a couple of reasons. One, it's still applying to rescissions. So the assessor is going to learn about the property no longer being entitled to the exemption in practically 1 of 2 ways. Either a rescission is getting filed, or they're learning the facts and they're either exercising their authority to issue the denial, or they're learning about the denial from the county or Treasury. So just reading the statute in its entirety, there are separate clauses within all those varying other subsections identifying to the assessor what they are supposed to do when those denials occur under those particular subsections. And again, going to address the argument advanced by amicus that's trying to narrow the scope of that phrase, unless the claim is denied under the section, is limited to a new claim. Under the statute, Treasury can be the entity that's denying that new claim. And that goes to reading subsection 2 and subsection 7 in harmony with subsection 8. Subsection 7 allows the assessor to forward the copy of the affidavit to Treasury with recommendation to issue the denial. And then Treasury would be exercising that denial under its authority in subsection 8. So that phrase, unless a claim is denied under the section, is already bringing in the rest of the section. It's not limited to just the assessor. if that makes sense, Your Honor.
Okay, thank you. The Court of Appeals makes reference to the fact the property was purchased in 2016. It seems to me the tax tribunal suggested the property in Arizona was purchased in 2017. If it in fact was purchased in 2016, would not the Arizona exemption gone into effect in 2016? And does that matter as it relates to how this case plays out?
Sure, I believe and record demonstrates, and it was attached to Treasury's exhibits to the tribunal, that the property was purchased, I believe it was October 2016, for approximately $400,000. It's unclear whether, and just going to the operation subsection 3A, it's unclear from the record whether or not the exemption was granted in Arizona in 2016. But what we do know is it was granted in 2017. There's no factual dispute about that, which explains why it was denied in 2017. And it's still unclear whether 2016 was ever reviewed, which that review is still discretionary, but it's an impact this case.
Thank you.
Justice Viviano?
No questions. Thank you.
Counsel, you have some time left. You can continue or reserve, up to you.
Well, I do want to thank this court for taking this issue up on appeal. It obviously is going to impact the state of Michigan and how so I did, on behalf of the department, want to say thank you. Obviously, we're asking that this court reverse the Court of Appeals and just address the plain language. The statute's fairly explicit that subsection 4 does not apply to denials. There are numerous provisions in subsections 5, 6, 8, 11, and 15 that's going to conflict. I believe subsection 5, dealing just specifically with conditional rescissions, is fairly explicit that the denial is retroactive and goes into effect the preceding December 31st. Subsection 15 goes the opposite way, dealing with situations where a rescission form is filed. So the statute is fairly comprehensive. It deals with a number of different fact patterns. Again, at issue is just subsection 8, the interplay between subsection 8 and subsection 3 because of the denial issued by the Department of Treasury. But if possible, I will reserve the balance of my time for rebuttal.
But before you do that, let me just follow up on my last question, if I may.
Yes.
And subsection 3A states that a claim for a substantially similar exemption in another state occurs at the time of the filing or granting of a substantially similar exemption. So if in fact the purchase was made in October of 2016 and at that time he was granted the exemption, would that not trigger the claim in 2016 and make this entire question about 2017 irrelevant?
It wouldn't make the question about 2017 irrelevant for the fact that he was granted the exemption, the substantially similar exemption, in 2017 by itself. It does raise the question of whether this particular individual should have been denied a PRE in 2016. But 2016 and 2017 are separate tax assessments being billed. So we know it was granted in 2017, the substantially similar exemption. That would render him not entitled to the exemption in 2017.
Okay, thank you.
You may reserve the balance of your time, Mr. Ziehmer.
Thank you, Your Honor.
Mr. Long.
Good morning, Chief Justice McCormack, Justices of the Supreme Court. May it please the court, my name is Jason Long. It's my privilege to be here on behalf of Amicus Curiae, the Real Property Law section of the State Bar of Michigan. On behalf of the Executive Board, the Council, and the RPLS as a whole, I thank the court for this opportunity to participate in this case. I intend to discuss a few things during the time that the court has granted. First, I want to talk about the same language that Mr. Ziehmer discussed, which is the "and unless the claim is denied" passage in MCL 211.7 CC sub 4, because we don't think it works the same way that Treasury thinks. And second, I want to talk about how what we think is the correct interpretation aligns with the principle of uniformity set forth in the Michigan Constitution. And if there's time, I will address a little bit more of the language at the end of subsection 4, including how the December 31st date applies to all the scenarios there. To begin, the issue in this case involves the duration of a principal residence exemption that's already in place when the owner becomes no longer entitled to it. Unfortunately, there's not an issue that Mr. Campbell lost the exemption when folks in Arizona granted him a comparable tax benefit on a home that he purchased there. For better or worse, the legislature has given us a rule that says when you get a benefit in another state, regardless of whether you intended to get it, that costs you your PRE in Michigan. But the RPLS submits to the court that the governing statute provides that for an owner who is already receiving a PRE and no longer qualifies because of the events in another state, the PRE continues through the end of the year in which the qualification ends. And that's subsection 4. And it begins with a directive to assessors. The directive is that upon receipt of an affidavit claiming the PRE, and unless the claim is denied, the assessor shall exempt the property until December 31st of the year when the exemption doesn't apply anymore. And it's important that the phrase "unless the claim is denied" is preceded by the conjunction "and." It's conjunctive to the assessor's, quote, receipt of an affidavit claiming the exemption. To give effect to the conjunction means that this refers to these two things together. First, the assessor receives a claim, and second, if it's not then denied, you put it on the rolls, or you put it on the books, I guess I should say, and it stays there until something happens that causes it not to apply anymore. Second, if the phrase "unless the claim is denied" refers to a denial that takes place at any time, it sure seems to us that it leaves the rest of subsection 4 without much meaning. Under the PRE legislation as a whole, the PRE can be denied for many reasons. It can be denied because of something that happens in another state, as happened with Mr. Campbell. It can be denied because the property has been transferred or because it's not being used as a principal residence anymore. It may be used as a second home or a rental home. If the phrase "unless the claim is denied" applies to every denial, I'm not sure when the December 31st termination date set forth in 211.7 CC sub 4 would apply. We wouldn't need a provision telling us that it carries on through this end of the year when the owner no longer applies if all that was necessary was a simple denial. Reading a simple denial is all that is necessary when an existing PRE ends creates a surplus language, and the court has to issue an interpretation like that. I also would like to address a point that the Treasury discussed in its briefing, which is that
why don't I interrupt you first, Mr. Long, and see if there are other questions, and then we can get back to that, assuming there's more time. And I'm going to start with Justice Bernstein.
Hi, counsel. Good morning, and thank you for appearing. I guess my question is, and I always like to look at the practical implications of this. If this court were to rule against your position, what would the impact be as it pertains to how this would affect the real property section?
Well, one of the reasons that the real property section decided to accept this court's invitation was that we think that the statute itself, and as applied by the Court of Appeals in its opinion, lends itself to easy understanding in a situation where whatever is going to happen with the property is going to happen at the end of a year when things sort of wrap up. You won't have a situation where you have to figure out when something was denied, what that, and it's denied when, well, let me put it this way. when someone loses the right to an exemption, because that depends on something in another state. And there might be as many scenarios for that as there are states, at least, I guess, 49 others. So to avoid, needing to understand that when you're doing a transaction or you're helping people with tax planning, it's helpful to have a rule that just carries through to the end of the year. And we think we have that. We think the statute provides for it. We think the Court of Appeals explained it. We think that a different approach that might give you a denial on any given date of the year is much more difficult to administer. So that's really a big focus of the RPLS is advocating for the efficient administration of justice, and we think our position does that.
So really, at the end of the day, it's really to help with clarification. You're basically just simply saying, if this term or condition comes to an end, just let it come to an end at the end of the year, and it just allows for easy bookkeeping and easy understanding for these transactions to take place. And your concern is that why create ambiguity or unnecessary confusion?
I think that's true, Justice Bernstein, but I want to emphasize that we also think it's what the statute says. I wouldn't be here telling you, let's have an easy way to do it.
Right.
If we thought the statute said something different.
And your argument is it makes sense that the statute would say this.
Yes, I think it's both Mr. Ziehmer and I think we have plain language on our side. We think the language of the section explains it the way we think it works.
Okay, thank you, counsel.
Thank you.
Justice Clement,
No questions. Thank you.
Justice Cavanagh,
No questions.
Justice Welch.
I do. Thank you. Thank you again, Mr. Long, for appearing and making sure we have a robust discussion here. So we really do appreciate it.
My pleasure, Your Honor.
So we have this 150 plus year history of construing ambiguous provisions in our tax rules pretty narrowly. That's a long-standing principle for construing legislation. And given the debate today, it seems that one could certainly argue that the section 4 we're talking about is open to multiple interpretations and arguably ambiguous. And I'm just wondering, what is your opinion on that, and why we wouldn't then look to the rest of the language surrounding it that Mr. Ziehmer pointed out that would help us construe that ambiguity?
Well, I think there's maybe a couple of sub-questions in there. First, I wouldn't urge the court not to look at the rest of the section, because I think I think we'd all agree that the court has to read the legislation as a whole and try to interpret it in a harmonious way that accounts for all the language there. So to that extent, I don't suggest that the court should not look at those other provisions. We think those other provisions, work in conjunction with our position. With respect to the sort of the narrow construction canon that you referenced, it's certainly been around for a long time. There are no shortage of opinions referencing that. But I think it's something that this court and many courts have started to shift away from, saying we're going to put, it was in Justice Zahra's opinion in Sanford versus State, where he said, we're not going to put a thumb on the scale for any particular kind of interpretation. We're going to look at the language, give it the reasonable meaning that it has, and read it fairly, and not try and push it toward one outcome or another, because it's something that there are some older cases that say we should read it liberally or read it strictly. Let's just read it reasonably, and the consequences are whatever they are. So I think my opinion on that is it's, as I've said, there's many cases that say it, and I know the court has utmost respect for precedent, but the court's more recent precedent has said we're going to maybe temper the application of that and just give every piece of legislation a fair and reasonable reading. And that's what I would urge the court to do in this instance.
Thank you.
Justice Zahra.
No questions. Thank you.
Justice Viviano.
No questions. Thank you, counsel.
Counsel, you may continue.
Okay, the other matter that I wanted to address, and I'm going to try and be brief because I see that I'm running short of time, is that there's an argument that Treasury offers the court that says the interpretation that I'm here suggesting would leave a provision in subsection 3 without meaning, and that provision says something like a person's not entitled to an exemption under this section in any calendar year in which, and then it's in which something happens, like you get a benefit in another state or you file a tax return as a resident of another state. And I would emphasize to the court that applying subsection 4 the way we advocate doesn't eradicate that language. Again, this is language that says if any of those things has happened, then you should be denied your PRE in the first instance. There has to be circumstances where a person already is receiving a PRE and then something happens in another state. Otherwise, that last passage at the end of subsection 4 that says a PRE is going to continue until December 31st of the year in which, and you skip to the end, the owner no longer qualifies because of subsection 3, means that there's going to be a circumstance where someone is getting a PRE, something happens in another state that makes them no longer entitled to that PRE, and it carries on through the end of the year. Notwithstanding their lack of entitlement, because it's dealt with at the end of the year. Related to that, I want to talk about rescission for a moment. Briefly, a rescission is when a property owner basically voluntarily relinquishes its PRE. Something happens, they move to another state, or they decide to use their home as a rental home, or what have you. And they submit something to their local city or township that says, we're relinquishing our PRE, we're not going to use it for our principal residence anymore. There is a separate provision that specifically governs the rescission of a PRE. It's in subsection 15, and it says when a property owner rescinds their PRE, the PRE nevertheless continues until the end of the year in which the owner submitted its rescission. So it's a very similar structure to what we believe subsection 4 provides. But the important point is that what that shows is that subsection 4 is not isolated to rescissions, because there's a different and specific statutory provision that applies to rescissions. So subsection 4 has to be able to be applicable to denials. Otherwise, I don't know what it does apply to, because it wouldn't apply to rescissions because those are governed by subsection 15. I think that reinforces our reading of the "and unless the claim is denied" language as applying when someone applies for a PRE in the first instance, gets it, and then subsection 4 addresses what do you do when things change. And an important part of that is that subsection 4 emphasizes at the end, and it's in both the provision governing when a property is not used as a PRE and when something happens out of state. It says when an owner is no longer entitled to it. For an owner to be no longer entitled to it, the owner must have had it at some point. So if they've had it at some point and things change and they're no longer entitled to it, regardless of whether it's a rescission or denial, what subsection 4 says is that it carries through to the end of the year when that happened. Another quick point, Mr. Ziehmer mentioned conditional rescissions, and that those end as of December 31st of the year preceding when the conditional rescission goes away. Real quick, it shows the legislature knew how to do this differently when it wanted to. It didn't do it in this instance. It said it carries through to the end of the year, the same year that something changes. With the conditional rescission, it's very detailed, and I'll try not to bog the court down, but basically it says, for example, there's a provision that a lender can get a PRE on a home that's foreclosed as long as the borrower continues to stay there. But if the lender doesn't do what it has to do to keep that, the conditional PRE goes away, and it goes away as of the end of the year before. In our instance, it goes away at the end of the same year. So it allows it to carry through to the end of the year, notwithstanding that something changed, because that's easy, that's straightforward, that's simple to understand, and that's better for everybody. I see that I'm running out of time. My 15 minutes of fame are almost up. I would just mention to the court, we think that this aligns with the constitutional uniformity provision. It's explained in our brief, and I'll stand on that for that point.
Thank you very much, Mr. Long.
pleasure.
Mr. Ziehmer, you have some time left.
Thank you, Your Honor. Just to begin and clarify, subsection 15 is not nearly as broad as it was previously indicated. It applies to a narrow situation. So it begins with the language, what happens when an individual has a PRE already on a property and they file a PRE on another property in the state within Michigan. And then it goes on to discuss, and it draws a distinction between situations where the person files a voluntary rescission form on their prior property and the situations where they do not. And the language in that subsection, the last sentence actually supports Treasury's position, which it begins with the word however. It goes on to say interest and penalty shall not be imposed on any calendar year in which that rescission is filed. The import of that is interest cannot be accruing unless there's a principal balance. And that's in reference back to subsection 6, 8, and 11 that are identifying that after that PRE is getting removed, it's being denied and getting removed, a corrected bill is being issued. And it goes to the question is, what is the corrected bill being issued for? And the only way that makes sense, it has to be getting assessed for that additional balance that would otherwise be due and owing for that calendar year. Because that's the only way.
I just want to ask a question, and I totally hear your argument and I totally hear what you're saying. I just want to ask you a big picture question. Why is this of such grave concern to the Treasury Department? I mean, we're talking about the end of the year. The real property section is saying that, you know, they read it a little differently than you do, but their argument is that, look, why not make it simplified for people? And you just simply indicate that it goes towards the end of the year. Why is this, what I'm trying to understand and explain to me from a big picture perspective, you know, why is this of such grave importance and significance to the Treasury Department to kind of take the position that you're taking? What's the ramification if the court were to go with the property section?
Sure. Yes, Justice Bernstein. And 2 quick points. The first point is we already believe it's pretty uniform. Again, we're always talking about December 31st. It's just which December 31st. The second point is we're talking about billing and the ability to collect taxes that are lawfully due and owing. So if we take the real property section's position, those additional amounts are never going to get billed because all the person has to do is file the PRE affidavit the next year. And the exemption goes back on the books. So in other words, unless the statute's read to allow the denial to actually have effect in meaning, and that exemption be able to be removed and those additional amounts be billed, then there is no practical consequence. There's no incentive for people to file voluntary rescissions. And some of these issues may never get adjudicated in a court. It's a lot cheaper to just receive the denial and then just wait until next year and file a new PRE affidavit, which is going to put the exemption back on the books for an entire another calendar year. It's a lot cheaper to and practically.
I guess my question would be, and I totally hear what you're saying. Does this happen a lot? I mean, we're talking about people who have numerous properties. I mean, is this like a significant issue that's like playing out, you know, quite often?
Well, gamesmanship always plays out in the PRE world. In terms of the practical effects and consequences of the Court of Appeals decision in this case, just because of the nature of the way tax administration works, we're not going to know the full effects for a long time and for at least a couple more years. And with the incentive structure to, rather than filing an appeal, just file a new PRE affidavit on the same property the next calendar year, these issues may never make it to a court to actually adjudicate. So it's unknown at this time.
Thank you, counsel.
Unless this court has any further questions for me, I see that I'm getting close to running out of time, although it's about 1 minute left. If there are no further questions, we're asking that this court reverse the Court of Appeals decision and clarify the statute, that subsection 4 does not apply to denials.
Thank you very much, Mr. Ziehmer, and thank you both for your presentations. This case will be submitted.